All right, here's the situation. Got a property that's listed for sale. Buyer's walking through, taking a look at things, really likes it. They go into the basement, check out the basement bedroom, and they notice on the bedroom window there are bars. Buyer says to the seller, "What's up with the bars on the basement bedroom?" Seller says, "Well, years ago we had a break-in, but there's been no instances ever since, and we left them up just to be safe." Buyer says, "Well, I think if I was to buy the property, I'd want to take them down." And the seller says, "Well, I don't think that would be such a good idea." So let's say the buyer purchases the property, transaction closes. Buyer moves in. A few months later, the buyer is talking to some neighbors, and the buyer learns that there's violent crime in the area. That for the past few years, there has been a rapist at large, and that the rapist actually broke into that home through that basement window and raped and assaulted the teenage girl that was living in that room. Now, the buyer, having her own teenage daughter, is now panicked, knowing that the perpetrator is still at large in the area. She now sues the seller and the former real estate agent for not disclosing that information before the sale. All right. So if you're the judge, how would you rule in this case? On the one hand, the buyer is arguing that that information should have been disclosed. Now, the seller and the real estate agent's defense is that they had no duty to disclose that information to the buyer, that the law requires only that sellers and agents disclose defects about the property, and specifically defects that cannot be discovered through a reasonable inspection of the property. The crime that occurred in the basement had nothing to do with the home. It was not a defect of the property. It was an event that created this psychological stigma that's now affecting the buyer. But there's nothing wrong with the home. Therefore, there was no duty to disclose. So if you were the judge, how would you rule in this case? You've heard both the arguments. What do you think? Well, this is the exact set of facts that happened in an Ohio case that really explored the nature and dynamics of stigmatized property. Let's break it down. All right, so as mentioned, the basic facts of this case is that there was a rape that occurred in the property. But beyond that, it had happened to neighboring properties as well, and that's significant. We'll talk about that in a little bit. So the buyer moves in, and they are not told of what happened in the basement or the surrounding properties. And so they move in and they find out from neighbors about what's going on in the area and what happened in the bedroom. The buyer has their own teenage daughter, and so of course they're upset about not having that information prior to the sale. So they sue for non-disclosure. Now the defendants defend on the grounds that this is a case of caveat emptor, buyer beware. That the only thing the law required that they disclose was latent defects. Those defects that were in the property that could not be discovered but through a reasonable investigation of the home. Now this raises really interesting questions. Most real estate agents are well versed in stigmatized property law in their state, and most states have either statutes or case law that really lay out the parameters of what constitutes stigmatized properties and the duty to disclose concerning them. Now, most states, not all but most, define a stigmatized property as a home that has had either a death in the property, such as a homicide or suicide, or the owner had some kind of infectious disease, such as AIDS or HIV, or some states even define a former meth house that was contaminated and then cleaned up and checked out by the State Department of Health and given the green light for new occupancy. Those are typically the main molds for stigmatized property out there. And some states also have some laws that say that haunted houses or paranormal activity in the home would also constitute a stigmatized property. Now, in regard to stigmatized property, those statutes and the case law typically state that a seller has no duty to affirmatively disclose that information. That is, that the seller does not have to come right out upon first meeting the buyer and disclose that there was this former suicide or that the previous owner had an infectious disease or that it was a meth home that has since been cleaned up. That information is, in a sense, protected by law, And now the only time that that information would come out is if the seller was directly asked. So those statutes, those stigmatized property laws, essentially shift the burden of disclosure onto the buyer, where the buyer, now, if they want that information, must ask. And if they don't, the seller cannot be liable when the buyer moves in and later finds out about whatever the issue is, and they're upset that they weren't informed. But this case is different, which is why it's so interesting. This case did not involve death in the property, and it didn't involve an owner who had an infectious disease like AIDS or HIV, and it didn't involve meth or any kind of paranormal activity. This case was about a crime that happened in the basement bedroom. Specifically, it was a violent crime. It was a rape at knife point, and then the perpetrator was out, and the surrounding homes also experienced the same crime. So does the seller have a duty to disclose? So the court sets that up pretty well when it says virtually all of the case law regarding the buyer's duties under caveat emptor focuses on physical property defects. Thus, the case at bar is unique in that it presents issues regarding duty and liability for a so-called psychological defect in the property, namely that the property was rendered unsafe for habitation by the plaintiff due to the serious crimes that had occurred in and near the residence. Now, I think that's interesting, that final little piece there that says not only was it in the residence, but it was also near the residence where these crimes occurred. So we could go out on a limb here and say, what if the crime never actually happened in the home, but just in those neighboring homes, and literally on the same street? Would the case still go forward? Could the buyer still make that argument that it should have been disclosed when now it had virtually nothing to do with the property? Well, the court seems to give a little teaser here that, yeah, this isn't just about the home. This is also about the immediate and surrounding area. That this buyer went into this area and this neighborhood and this home, and they presumed it to be safe, when in fact it was not. So that can lead us to venture a guess, and I think probably a fairly strong guess, that even if the crime didn't happen in that particular home, and just in the neighboring homes, that the court still would have heard this case and given it some serious consideration. Now, to the parties' arguments, as we've gone through, the plaintiff's argument is that that information should have been disclosed, right? It would have affected their decision to buy the property. And the defense argues that, look, first of all, we had no duty to disclose because it had nothing to do with the property. But even if we did have such a duty, we still didn't need to disclose it because that information about what happened in or around the area is readily discoverable through a reasonable inspection. The buyer could have gone to the police station and checked the data on the crime in the area, and that would have given the buyer everything that they wanted to know. The court says, defendant's argument that the defect at issue was readily discoverable lacks merit. Checking police records in order to ascertain the relative safety of a neighborhood or a particular residence would not be an action undertaken by even the most prudent of purchasers. Now, the court is pretty clear here that when the law says that a seller or an agent must disclose the defects that they know about but cannot be discovered through a reasonable inspection of the property, well, what constitutes a reasonable inspection? We have to look at what most buyers are going to do in a transaction, how they're going to perform their due diligence. And most prudent buyers are not going to go to the police station and ask for the criminal reports that have been filed about the property or the surrounding area. They just don't do that. The court is essentially saying, look, you can't just pawn off every little thing onto a buyer in the name of due diligence and caveat emptor. It doesn't work like that. And we have to figure out, well, does the seller have a duty to disclose that information or not? In determining whether or not the seller and the seller's agent had any liability for non-disclosure in this case, the defendants point to non-disclosure statutes, essentially those stigmatized property statutes that relieve sellers and owners of liability for not disclosing that information up front. The defendants in this case have argued that the prevailing trend across the nation regarding property disclosure is evidenced by the non-disclosure statutes that have been enacted in 20 states and the District of Columbia. Defendants also contend that these statutes imply that a cause of action for tainted property in Ohio is necessarily barred. These statutes generally state that sellers of real estate are not liable for failing to disclose stigmatizing events, such as the fact that a homicide, suicide, felony, or death by AIDS occurred in the residence. But the court shoots that defense down. The court says it is the opinion of this court that the non-disclosure statutes still require a good faith response to an inquiry regarding a potential psychological impairment. Non-disclosure statutes are not designed to allow sellers to make false representations regarding property defects in response to affirmative questioning by the buyer. So the court essentially says, look, even though there's no liability for non-disclosure, you still have a duty to answer the inquiry from the buyer. So with the court establishing that the non-disclosure stigmatized statutes will not impose liability unless asked, and the seller doesn't answer honestly, the court now looks to the situation to determine, did the buyer ask the seller about the crime in the area and in the home? The court says reasonable minds could construe the plaintiff's question regarding the bars on the basement windows as an affirmative inquiry directed at ascertaining the safety of the premises, and the seller's statements regarding the reason for the bars to be a misrepresentation or non-disclosure of their current purpose. Upon the buyer's inquiry, the seller was simply required to tell the truth. Now, when the court says reasonable minds could conclude, what it's really saying is that a jury could conclude that when the buyer was asking about the bars in the window, they were essentially asking about the safety of the premises and the area. And when the seller answered and said, well, we had a break-in a few years ago, but everything's been fine since, well, a jury could also conclude that that is not telling the whole truth. That is essentially misrepresenting what happened and misrepresenting the safety of the immediate area and the property. All right, so that sums it up with the seller. Sellers have a duty of honesty with the buyer regardless of whether the issue is protected by a non-disclosure statute or not. But what about the real estate agents? The burden on the real estate agent under this type of statute is potentially greater. An agent has the affirmative duty to seek out from the seller the information sought by the buyer rather than merely disclosing his or her actual knowledge without the duty of further inquiry. So kind of an interesting little note there that the court sticks in that essentially if you're a real estate agent selling the property and the buyer asks you about an issue that's protected by the stigmatized statute and you don't know the answer, you can't just say, I don't know the answer. You actually have a duty to go ask the seller, get the information, and then convey it to the buyer. The court says, by contrast, however, the court finds as a matter of law that the inquiry of buyer was directed solely to the homeowner. She alone responded to the buyer's question regarding the safety of the residence. The real estate defendants had no duty to affirmatively speak up and disclose their knowledge of the crimes simply because they were in the room at the time the inquiry was made. All right, so to me that's interesting. I don't know that I fully agree with the court's conclusion on the real estate agents. How about you? Essentially, we find out that the real estate agents were in the room with the buyer and the seller discussing the answer to the buyer's question about the bars on the window. And the seller says what we know, that there was a break-in and that everything's been fine since. Now, if you go back and look at the text, the court says, the real estate defendants had no duty to affirmatively speak up and disclose their knowledge of the crimes simply because they were in the room at the time the inquiry was made. I don't know that I would hang my hat on the court's conclusion here. Let's assume for a minute that the real estate agents had no knowledge of the crime that happened in the home. The court implies, though, that they had knowledge of crimes in the area. I think there are a number of courts that would hold agents liable for not speaking up or otherwise pulling the buyer aside later and saying, hey, you asked about bars in the window. Here's what I know about the crime in the area, and this might be why they're there as a precaution. Again, assuming they didn't know that there was an actual break-in. So the court's conclusion with the real estate agents, I don't know that that necessarily is good law that agents should trust and follow. I think a more conservative, precautious approach by agents would be much better, and that is to say, hey, let's disclose what we know just to be safe. And even if there is no duty to disclose, even if the court is correct, these poor agents would not have been looped into the lawsuit to begin with had they disclosed their knowledge about crimes in the area. All right, so what do you guys think? Did you like this case? Do you agree with the court's conclusion? Remember, most states have these non-disclosure statutes, these stigmatized property statutes, and many of them do lump in a felony in the property as something that is protected and not required to be disclosed by the seller unless asked. So do you think a question about the bars on the window is implicit of a question that now triggers the duty to be honest and disclose the information about the felony? Do you agree with the court's conclusion about the real estate agents? Let me know. Put your opinion in the comments below. And as always, remember guys, this is a case breakdown for educational purposes only. If you're dealing with a property that has a history such as this or similar, always talk to competent counsel in your area to figure out the disclosure requirements in your neck of the woods. Please like and share this video with agents in your office and home sellers and buyers that you know. And be sure to subscribe, hit the bell, and turn those notifications on so that you become aware of when we drop the next case. And we will see you in that next video.